For all your Canadian immigration needs, hiring an immigration lawyer has its benefits. He can appeal for you in the Federal Court of Canada and fight for you.
Recently, I've received a lot of inquiries about arranged employment, and it seems there's quite a bit of confusion around what it is, what it means, and where it fits in the immigration process. So I thought today I'll devote some time talking about arranged employment. In terms of immigration laws, according to the Immigration and Refugee Protection Act and regulations, it is one of the 6 factors under the skilled worker program where an applicant to immigrate to Canada gets additional points, anywhere between 10 to 15 points. It is not like work permit. There's a huge difference between work permit and arranged employment. Essentially, an arranged employment is a genuine offer of employment by a Canadian employer to someone who wants to immigrate to Canada. The employer has to meet certain minimum requirements. The application has to be submitted at HRSDC, a bit like the work permit application, but there's no need to advertise. There's no need for the employer to demonstrate that they have tried to recruit locally. It's simply an offer of employment to a prospective immigrant. The application goes to Service Canada, to the HRSDC, and it is processed in about, depends, usually about 4 to 5 months. Once HRSDC approves that offer of employment, then the employer has a positive AEO, Arranged Employment Opinion. That has huge benefits to the prospective immigrant. Number one is the prospective immigrant gets 10 additional points under the one factor that is known as arranged employment. And secondly, if under the factor of adaptability that prospective immigrant still has room, because the maximum points under adaptability is 10 points, that applicant will receive an additional 5 points, so up to 15 points, which is very, very useful to a lot of people who can't make the minimum 67 points, which is the current pass mark for a skilled worker application. But in my opinion, the biggest benefit these days to applicants in the skilled worker category is the expedited processing. At the moment, the processing time is horrendously long, 5, 6, 7 years in certain cases. So for people coming from countries where the processing time is far beyond over 2 years, it certainly helps. Usually the processing time is cut by 2/3. So if something takes 3 years to process, immigration will probably take about 1 year to process an applicant who has arranged employment in Canada. The third benefit to the immigrant is there is no need for that immigrant to to show settlement funds. Settlement funds is one of the requirements of a prospective immigrant. Depending on the family size, an immigrant has to show that he or she has a certain amount of money, which is known as settlement fund. So the third benefit is the settlement fund requirement is waived. If someone is already working in Canada on a work permit, that worker can also get points for arranged employment under the factor known as arranged employment, because that is one way of getting 10 points. So two ways a prospective immigrant, an applicant, can get points for arranged employment. One is to be sponsored by a Canadian employer who has made an offer of employment for an indeterminate period. The other way is if you happen to be in Canada working on a work permit, most likely, that too will bring you 10 points under the arranged employment factor, and another 5 points under the adaptability factor if there is room there for you. And the benefit to the employer is also very good, because unlike a work permit where you have to employ the worker from overseas, you're bound to that worker unless there's good cause for you to terminate the employment, then the worker has to go back. In this case, you are sponsoring an immigrant, someone who wants to come to Canada, someone who wants to be here long term, forever, and someone who wants to settle here, who wants to work. So you have someone who's committed to long term. If that worker works out for you, it's a tremendous benefit to the employer. And if at the time the immigrant gets to Canada, there's for whatever reason the employer is unable to employ that worker, there is no hard and fast rule. There's no serious consequences. However, the offer has to be genuine. The employer has to provide a job offer to the worker, and the worker has to have the experience and qualifications in the field that the job is being offered. If you're a doctor and you're being offered a job as a hairdresser, you will not be able to qualify for arranged employment points. So my advice is always ask questions, do your research. There's lots of information available on the internet, but there's also a lot of bad, misleading information on the internet. So talk to a lawyer, talk to a Canadian lawyer who is experienced in immigration and who has experience dealing with arranged employment, and hopefully you would have benefited from today's program.